Right, so we're on the record. Good morning.
Morning, Your
We're on
Honor.
the record in docket 22-03115.
Good morning, Your Honor. Oh, sorry. Did you call for?
Yeah, I will in a second. And the 23-01912. It's people of the state of Michigan versus Aaron Griffiths. The parties, please introduce themselves for the record.
Thank you, Your Honor. Andrea McCray appearing on behalf of the people. P number 83698 appearing on both files.
And good morning, Your Honor. Jared Austin appearing on behalf of Mr. Griffiths. He appears with us today remotely from the Ingham County Jail.
Sir, you are Aaron Joel Griffiths?
Yes.
Okay. And you can hear me all right, Mr. Griffiths?
Yes.
All right. This is the time set for a probable cause conference. How are we proceeding?
Thank you, Your Honor. After speaking with brother counsel, we are going to leave the matters on for preliminary examination next week. Thank you.
All right. Is that your understanding, Mr. Austin?
That is correct as to both files, Your Honor. Yes.
So that's put on for prelim on July 7th at 8:30.
Is there a PA 53 scheduled for the same time as the prelim in one of the files, Your Honor?
Let me see. I think on the 115 file, there's also a prelim on the PA 53. Set for the same time. I'll leave that on for July 7th at 8:30. Is that correct?
Yes, Your Honor.
Yes.
So, Mr. Griffiths, your preliminary examination, your probable cause conference is done. We're leaving the prelim and the PA 53 violation on for next week at 8:30. All right, sir? All right. Anything else for the record in docket 22-03115, 23-01912? Ms. McCray.
No, thank you, Your Honor.
Mr. Austin?
Nothing additional, Your Honor.
All
Thank
right,
you.
Thank you. You're all set, Mr. Griffiths. Thank you for your appearance today.
I can get on my computer, but I will certainly make a request to get back with you.
Is that Ms. McCray too, or is that Mr.?
Ms. McCray is gracious enough to stay there while I'm doing Ms. Miracles.
All right. And Mr. Barnett is,
In custody, Your Honor, we're just going to leave that matter on.
all right, let's go ahead and call that.
Thank you.
So we're on the record in docket 23-01886. It's people of the state of Michigan versus Deputy C. Barnett. Ms. McCray and Mr. Sartz, your appearances for the record.
Andrea McCray appearing on behalf of the people. P number 83698.
Good morning, Your Honor. Jacob Sartz, the fourth assistant public defender here on behalf of Mr. Barnett. I'm appearing in person. Mr. Barnett is appearing by Polycom from the Ingham County Jails.
Thank you. And sir, you are Deborah C. Barnett?
Yes, sir.
Okay, and you can hear me all right, Mr. Barnett?
Yes, sir.
All right, this is the time set for a probable cause conference. Ms. McCray, I think you indicated, how are we proceeding?
Thank you, Your Honor. We are going to leave the matter on for preliminary examination next week.
And is that correct? Is that a correct statement, Mr. Sartz?
Yes, Your Honor. Thank you.
Left on for preliminary examination on July 23rd at 8:30. All right, Mr. Barnett, your probable cause conference is done. We're leaving your prelim on for July 23rd at 8:30 for next week. All right, sir?
You said July when?
July 23rd at, I'm sorry, June 23rd. Oh, July 7th. Wow, I don't know where I got the 23rd from. Oh, I see where I got it. 2023. July 7th, July 7th at 8:30. It's a week from today.
All right, thank you, sir.
All right, thank you.
Thank you, Your Honor.
That's all for the record in docket 23-01886.
Thank you, Your Honor. I believe in regards to Judge Buchanan's docket that Mr. Carter and I are ready on Richard Weck. I believe Mr. Weck appears to be too.
All right. So we're on the record in docket 23-01882. That's people of the state of Michigan versus Richard Weck. For the parties, please introduce themselves for the record.
Andrea McCray appearing on behalf of the people. P number 83698.
May it please the court, David B. Carter Jr. on behalf of Mr. Weck, who is present by Zoom, and I would waive his appearance.
All right. Let's see if I can find him. Just to see him, or do we need to let him in?
I need to.
I see. And sir, you are Richard Weck.
No,
Yes,
I'm Emilio Betancourt.
Oh,
Oh,
thank
Sorry
you,
about
Mr. Betancourt. I'm talking to Mr. Weck. So,
sorry.
Sir, you are Richard Weck.
yes, I am.
Okay, and you can hear me all right, Mr. Weck?
Yes,
All right. This is the time set for a probable cause conference on a case, on a Judge Buchanan case. Ms. McCray, how are we proceeding?
Thank you, Your Honor. After speaking with brother counsel, I believe that we are going to be asking for a new date due to brother counsel being out of town for the preliminary examination that was scheduled for next week.
And is that correct, Mr. Carter?
It is, Your Honor. I have a scheduled vacation that day.
All right, and so.
And I did explain that to my client. I also explained to him that I'd be asking him to waive his 21 days.
All right.
I've also indicated to him that he's not waiving his preliminary exam, just his right to have one within 21 days of the date of submitting.
All right. May I inquire of your client of his waiver of the 21-day rule?
You may, Your Honor.
All right, Mr. Weck, Mr. Weck, you understand you have the right to a preliminary examination within 21 days of your date of arraignment. You understand that, sir?
yes,
And the preliminary examination is a probable cause hearing in which probable cause would have to be proven by the prosecutor and the people of the state of Michigan that there's probable cause that a crime was committed and the identity of the person who committed that crime. You understand that, sir?
yes,
You are, of course, represented by Attorney David Carter, and he would be present to contest any charges or cross-examine any witnesses brought against you on that date. You understand that, sir?
yes,
It's my understanding you wish to waive your right to a preliminary examination only within that 21-day period, not to a waiver of your preliminary examination in general, just within that 21-day period. Is that correct?
yes,
Okay, I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made, and we will get a new date.
I was given the date of July 14th at 1:30.
Does July 14th at 1:30 work with your schedule, Mr. Carter?
I can make that work.
All right, so we'll reschedule for July 14th at 1:30. Anything else for the record in docket 2301882, Ms. McCray?
No, Judge, thank you.
Mr. Carter?
No, thank you, Your Honor.
All right, Mr. Weck, please keep in contact with your attorney, David Carter. Your preliminary examination has been reset for July 14th at 1:30.
okay,
All right, you're free to leave the Zoom courtroom. Thank you for your appearance today.
thanks, you.
That's fine.
Weck,
Yeah, let's do
right?
it. How long is it gonna be?
Is that?
Okay, so we'll
So we're on the record, docket 2301-874. That is People of the State of Michigan versus Dallas Williams. And docket 2301-878. Make sure I've got both files. I only had one. So 2301-874 and 23-01-878. Will the parties please introduce themselves for the record?
Andrea McCray appearing on behalf of the people on both matters.
Mike Pantaloni on behalf of Mr. Williams.
Thank you. And this is the time set for a probable cause conference. It's my understanding, Ms. McCray, that the defendant is not here today because he's still writ in jail. Is that correct?
That is correct, Your Honor.
And it's my understanding today that this is just going to be left on for preliminary examination for that July 7th date. Is that correct?
Yes, Your Honor.
Yes, sir.
All right. So we'll just leave on for preliminary examination for that July 7th, 2023 date. Anything else for the record in either docket 2301-874 or 2301-878? Ms. McCray.
No, Judge, thank you.
Mr. Mataloni?
Nothing.
All right. Good to see you, sir.
Have a good holiday.
You too.
Yes, I'm sorry. I should make that.
Judge, in regards to Judge Buchanan's docket, Cody Navarro, we're just gonna leave that on. Brother counsel is here and so is the defendant.
All right. We'll just leave that on.
Do we need to go on record? No? Okay.
Thank you.
See you next week. Navarro, Cody Navarro. Yeah.
He's freaking out.
All right. So Mr. Navarro, are you there? Nope. Left an empty seat for us.
Oh, Corey Navarro is ours. Their Navarro's not on.
All right. So Navarro is I
We have a
can give you.
Navarro too.
All right. There's those three then.
Bye-bye.
Mr. Samores, you're here on your 8:30. You have to unmute yourself, Mr. Samores.
Yes, Your Honor. Thank you.
All right, and that's a civil case? And is there a Mr. Frost here on that case?
Good morning, Your Honor. Attorney Amanda
Amanda. All right.
of Whitney.
Let's go ahead and call that case. So we're on the record in docket 23-01032. That's Matthew Kemsky versus Whitney Christowiak. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Peter Samoris, attorney for plaintiff Matthew Zemsky, who's also present via Zoom.
Good morning, Your Honor. Attorney Amanda Frost appearing on behalf of the defendant Whitney Christowiak, who is also present via Zoom.
All right, this is the time set for, it looks like a live civil pretrial. Is that correct, Mr. S'mores?
Yes, Your Honor.
All right. Have you had the opportunity to talk to Ms. Frost and go over the pretrial statement?
We
or did you just want to do that on the record?
Well, I think, Your Honor, at this point, I think we just need to do it on the record. We weren't able to agree on a few things, but I have a suggestion this morning, which may help all parties, and certainly I think would help with respect to attorney fees. I just think if I'm correct on the law, I think my client would win, and I don't want to get into it too much because this is a bench trial, not a jury trial. And if Ms. Frost is right, I think she would win. So I think maybe dates for a motion for summary disposition, because basically I think the defense is that because she had to get a PPO over my client back in October of 22, that somehow absolves her from liability on the lease and unpaid rent. And our position is, well, yeah, I guess one of the judges in Ingham County Circuit Court did sign a PPO on October 14th, 2022. But a little over a month later, on November 18th, 2022, before Judge Garcia, it was terminated. And in fact, as we were waiting here this morning, I just sent Ms. Frost the order terminating the PPO and the removal of entry from lien. So to the extent that may absolve a landlord, and I'm not even sure which statute Ms. Frost is talking about, I don't think there's any dispute that Ms. Christowiak signed the lease and owes this money. And her defense seems to be one of a legal one, Your Honor. And that's why I was going to suggest either, if there's.
I'm more than happy, since we're here on a pretrial, we can fill out the pretrial form on the record.
Okay.
Ms. Frost, did you want to set this out? We can set it out for a motion for summary disposition, or how would you like to proceed? I do think we could, while we're here, we should just fill out the pretrial form.
I agree, Your Honor. I think we should fill out the pretrial form. I do anticipate that one of the two of us will probably file a motion for summary disposition at some point. I do believe that we do have a valid defense based on the PPO statute that allows a landlord to release a tenant from a lease and not be liable for it after they're released. So I do believe that a motion for summary disposition is forthcoming, but I believe that the pretrial statement will be helpful in the event that neither one of us do file that motion for summary disposition.
All right, let me, I've got the caption. How would you describe the issues, Mr. S'mores? And we'll go ahead and briefly fill this out. So for our civil department.
Okay.
Is this is a landlord tenant issue?
Well, no, Your Honor, my client would have been a co-tenant with his then living girlfriend. And that's where the rub is.
So how would you describe this issue in about 4 words?
Very well. Unpaid rent owed to my client, and with respect, and also money owed on the security deposit. This is a
and Ms. Frost, how would you describe this?
I would agree with Mr. S'mores. This was originally a civil claims case transferred to district court. The only things alleged is for unpaid rent and a portion of the security deposit.
Besides the summary disposition, do you anticipate any other motions, or is it too early to tell?
Did you want me to go first, Your Honor? I'm not sure.
Yeah, sure, Mr. S'mores.
Okay, thank you. I was just going to say there were 2 matters in small claims court. One got transferred. My client advises that he tried to transfer the other, but somehow it got dismissed. So I guess one potential motion for me is a motion to amend complaint, but even that's sort of a misnomer because I don't have a complaint, but there's an answer here. So it might be beneficial for the plaintiff to file the complaint. So I'm not sure how that would be raised, but.
All right, I'll put too early to tell.
Okay.
Ms. Frost, any anticipated motions?
Outside of a summary disposition, I have nothing anticipated at this time, Your Honor.
I'm gonna put admissions of fact are too early. Exhibits are too early. Do you have a date for discovery or is that still too early? Mr. Morris?
Oh, I'm so sorry. Whatever the court feels, I can gladly provide any documentation that's requested, formally or informally.
We'll do, we can do 90 days at this point, just for sake of filling out the form. Does that work, Ms. Frost?
That is fine, Your Honor. I would just request that it be limited to the scope of the claims made in the affidavit and claim that was submitted to the small claims court.
I'm gonna put expert witnesses not available, damages right now are not available, joinder of claims are not available. Has either party paid the jury trial fee?
I don't think any parties has requested a jury trial. With respect to the joinder,
Okay.
with respect to the joinder of claims, Your Honor, I guess I would respectfully request that be open because again, my client attempted to transfer this from, is what he advises, from the small claims court. And there were two cases in small claims court. One of them got transferred. That's the case we're here on. And the other one somehow got dismissed.
Yeah, I find that the pretrial statement is often way too early, not knowing all the matters. So I've kind of just left it open as not available at this time, or not applicable at this time.
Okay.
With that, is that fair, Mr. S'mores?
That's fine, Your Honor. If I guess
Okay.
I can always bring it to the court's attention, the what I call a procedural defect in small claims court, because I think both matters should have been transferred to general civil, but only this matter was transferred.
Okay. Ms. Frost, do you have any comment on that?
I strongly disagree. After reviewing the register of action for the other small claims, it was dismissed. There was a motion to set aside, that was dismissed. So I don't see that there's any reason to reopen that or bring those claims into this case. I have not seen the judgment to find out exactly what the judgment said. My client is going to obtain that for me, but at this point, I don't see that there's any need for joinder, consolidation, anything of that sort.
All right, I placed that and you placed that on the record. Is this a case that requires any type of case evaluation?
I would say not, Your Honor. I think my initial opinion or instinct was, I don't think there's a big dispute as far as the lease and what was signed and what may be owed.
All right.
That's all.
Ms. Frost?
I don't think case evaluation is necessary. Maybe mediation if we get to that point, but not case eval.
Okay, so I'll place yes, maybe for mediation. Mr. S'mores, do I have your authority to sign this as stated on the record?
Yes, Your Honor. Thank you.
And Ms. Frost?
Yes, Your Honor.
With that ease, that'll allow the pretrial to be done. And you'll both get a copy of this. I'll sign it as the pretrial. We put it on the record, and that'll save a step in the action. So pretrial was held, and I will await the civil department will set any motion for summary dispositions you might have. Okay.
Very well. I guess I forgot to point out, I'm not sure if this is even going to be an issue, but I am going to be out of state from August 9th through August 26th. Well,
okay, I can put that under.
I'm sorry.
Under other. August 9th through August
27th. I'm sorry.
27th. Okay. All right, I placed that under other. The pretrial statement is filled out. I've signed with authority for both. It's placed on the record. Anything else on this file, docket 23-01032, Mr. S'mores?
No, Your Honor. Thank you.
And Ms. Frost?
I have nothing further, Your Honor. Thank you.
All right. And did one of you say your client was here?
I think both litigants are here, Your Honor.
Both
All
claims.
right. All right, so I would thank Mr. Zemsky and Ms. Christowiak for their appearances today. You're all free to leave the Zoom courtroom. Thank you for your appearance.
Thank you.
Thank you, Your Honor.
Yes. Mr. Asbach, what case are you here on?
Good morning, Judge. I am here on Cedar Place versus Betty Porter.
All right. Let me grab that file. All right. And that was a previous default, and then is that a
Yeah, essentially, Judge, it's our motion for issuance of a second order of eviction. The
right.
previous one was issued, but we thought she was going to get rental assistance to cover the rent, but it never happened.
All right. And I do not see, is Miss Porter in the physical courtroom? And I don't see Miss Porter here. All right. So we're on the record in docket 22-02874. That is Cedar Place Apartments versus Betty Porter. Will the parties please introduce themselves for the record?
Christopher Asphalt 53129 on behalf of the plaintiff.
All right, this is the time set for a motion in the matter, and I do not see a Betty Porter in the Zoom room. There's nobody answering to the name of Betty Porter in the physical courtroom. This was scheduled for 8:30. It is now 9:03. It would appear that Betty Porter has failed to appear today. And I do have notice was sent by your office before the honorable for today on June 16th. Is that correct, Mr. Asbach?
That is correct, Judge.
That's what I have.
Okay, very good.
Is that correct, Mr. Asbach?
That is correct, Your Honor.
All right. How do you want to proceed, Mr. Asbach? It would appear that the defendants failed to appear today.
Your Honor, I would request that the court grant me the authority to submit a second order of eviction to the court for entry.
Okay. It's based on the nature of the motion and based on the defendants failed to appear. And there was a previous fail to appear on a default judgment, and this has been come back on a reservice. I will grant the motion to file the eviction. And you'll follow that up with an order, Mr. Asbach?
Yeah, I'll just submit a new writ, Judge, if that's okay.
All right. That'll be perfect.
Thank you, Your Honor. Have a good weekend.
You too, Mr. Asbach. Thank you. That's all for the record. 22-02874. Is there anybody here representing Credit Acceptance Corp?
Yes, Your Honor. Good morning. Josie Lewis.
Okay, your name is Miss Lewis,
Correct. And I'm
All right.
P69317.
and is there a Latoya Flanagan? Right. Miss Flanagan, you're here on Zoom?
Yes.
Yeah, they finally put a new one in a couple days ago. So far, it's working.
Although the truth in advertising, it tells you how much time, when they highlight it, how much time battery. Never lasts that, even close to it. Never.
I just muted him. All right, so we're on the record in docket 1400828. That is Credit Acceptance Corp. versus Latanya Davis or Latanya Flanagan. Will the parties please introduce themselves for the record?
Yes, good morning, Your Honor. Josie Lewis, appearing on behalf of plaintiff on P69317.
And ma'am, you are Latanya Flanagan or Davis?
Yes, it's Latoya Flanagan.
All right, and this is your motion, ma'am, on objecting to the entry of the order. Did you want, I have your motion here indicating that you fell behind on a couple things due to having an eye surgery. No payments were made, but if allowed, we'll make all missed payments in one lump payment. If direct withdrawals is just set it up for automatic withdrawals. Is that the nature of your motion today?
Yes, it is, but I went ahead and paid $800 on the 28th, just to show that I will pay, get caught up on everything. On the 7th of July, I can pay off the rest of the $300 that's owed, and then I should be back in the swing of things.
Ms. Lewis, you're here as an objection to the motion. What is the current balance that's outstanding?
$19,995.85.
Say that again, ma'am. I didn't hear the first number.
Sure, $19,995.85.
Ms. Lewis, have you had the opportunity to speak to Ms. Flanagan about this outstanding balance?
No, but I don't think there could be a resolution here. I mean, the problem here, Judge, is she didn't make a payment under the installment payment order. And I do agree that she paid $800 yesterday, but she's not fulfilling her promises with the installment payment order or with the objection to her order. When you read her objections that you just read, she said she would make one lump sum payment to make it all up, and that didn't happen. She was $1,600 behind. She did make an $800 payment, but again, didn't fulfill her promise and her objection. So we still have an issue here because she's not caught up.
Well, Ms. Flanagan, go ahead. But I do see Ms. Lewis's point. I have to base this based on a meritorious claim. That there's some meritorious claim here. And what I see here is you need more time to make up your payment schedule.
Well, I paid the $800 as a good faith to show before court.
Right, but you're still behind.
Yes, I am. I didn't pay the full balance because, it's like, I didn't know what you were going to say as the judge, if you were going to accept the offer. That was an offer. So if the offer was accepted, then the rest of the money would be paid off. So that's the only reason why the rest of it was not paid yesterday. And
Ms. Lewis, your response?
Well, we wouldn't agree with that offer, Your Honor. I think my client has been very patient. This is a $20,000 balance. Even at $200 a month without interest, it's still going to take her 9 years. And like I said, this installment payment order was November 2022, 8 months ago. And we haven't received any payments until just before court. So I understand that she's trying to show some good faith, but she still hasn't made up her missed payment. So we would reject that offer. We'd ask the court that set aside the installment payment order and let us proceed with collection.
All right, Ms. Flanagan, anything else on your motion?
Yes, I do. Actually, I had surgery. I provide all of those documents for the court to remove a tumor in my lacrimal gland, which is a very rare situation. That was in January. So even though the arrangements were made, I was off of work, which it states in the letter. I was off of work for 3 weeks. So therefore, I got behind on a lot of things. And so, I'm like, I've spoken with you before, when we had the other hearing. My husband passed away in December of 22. So I had a whole bunch of stuff going on. Then I had an accident in March, which I can provide documentation for that, which involved physical therapy for me and my youngest daughter who was injured, as well as I. And so it's like all of those things going on. How am I supposed to give money that I don't have? How am I supposed to, abide by this order if I don't have the means to do that? So me being able to go back to work fully and get my paycheck, a full paycheck, I am paying what I can pay. So it's like with the eye surgery, I've had 2 eye surgeries on my left eye for a tumor. I've had 1 surgery on my right eye for the same condition. And if that doesn't work and I have to have a 3rd surgery, then we'll have to start chemo. So all of those things bunched into one. It's not that I don't want to pay. It's basically that I was unable to pay. And like I said, I can provide medical documentation for the surgery in January. I can provide the police statement for the accident. It's so many factors. It doesn't matter how long it takes a person to pay something off. If they are injured or going through health issues that could potentially be fatal, then, it's like if I'm deceased, how can I pay this bill? I'm trying to take care of my health. I'm trying to take care of my kids,
Thank you. Thank you, Ms. Flanagan. This sounds like a collections issue to me, Ms. Lewis, doesn't it?
Yes.
Yeah. So I'm gonna deny the motion to set aside, and I'll have this case proceed to collections because it seems like a collections issue at this point. So the objection to entry of order is denied, and this will proceed to collections. And Ms. Lewis, you'll follow up with a order to that effect?
I attached an order to my motion when I filed it.
I don't see one, but that doesn't mean you didn't do it.
And I can certainly send it in again, Judge.
If you resend it just in case, because I don't see it in the file, but it could be making its way to the file.
Okay, can I email that in or should I just drop it in the mail?
You can email it to my courtroom address, my email courtroom address.
Okay, sounds great. I'll get that done.
All right, thank you. Anything else for the record? 1400828, Ms. Lewis.
No, Your Honor, thank you.
Ms. Flanagan, do you have any questions of me?
Yes. So what does that mean?
It means that your objection is denied, and this really is a collections issue. It's not whether you owe the money, it's when you can pay it. And that's what the collections issue is all about.
Okay, so do I proceed with the $200 payments or?
It's whatever the credit acceptance will accept in regards to the collections, but this appears to be a collections issue. You probably want to get with credit acceptance and work out some terms of a collection agreement. I don't know, but the order that you indicated denying order, the order that you've indicated objections to the entry of order has been denied today.
Okay, all right, thank you.
All right. All right. Anything else for the record? That's all for the record. 1400828.
Thank you.
Thank you for your appearance, both of you. Mr. Yes.
Sorry, don't want to interrupt you.
Let me see if I can get rid of all our civil and then.
Perfect.
So, Mr. Sasong, you're here on the Renner Narot case.
JGA acquisition.
Acquisitions.
Yes, the Kimberly Fox, Your Honor.
All right. And is Kimberly Fox present or a representative of Kimberly Fox?
Ms. Fox does have counsel, Your Honor. Her counsel's name
Is that Mr.
Nerat.
Is that Mr. Nerat?
Yes, correct.
Is there Mr. Nerat in the physical courtroom?
Mr. Sosan is stepping in.
No, he's here for the opposing party.
I'm here on behalf of JG Acquisitions, Inc., Your Honor, plaintiff.
Right. You're here. Your opposing counsel is Mr. Nerat, and the opposing client is Kimberly Fox.
Yes, that's correct.
Mr. O'Neill, you're not here on this case, are you?
No, Your Honor. Actually, I'm here on Mr. Kelso for Pat.
All right. I was just checking because you're the only lawyer I see in the Zoom courtroom, and I know none of the lawyers in the physical courtroom are here on this case. So, Mr. Sasong, I'm going to go ahead and call your case because we're probably an hour into it. So we're on the record in docket 23-01102. That's JGA Acquisitions Inc. versus Kimberly Fox. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Christopher Sossong, spelled SOSSONG, P59383, appearing on behalf of the plaintiff, JGA Acquisitions, Inc.
Okay, and this is the time set for a pretrial in the matter. I do not see a Kimberly Fox in the Zoom courtroom. I do not see her attorney, Mr. Nerat, in the Zoom courtroom. I do not see a Kimberly Fox. Is there anybody who answers the name of Kimberly Fox in the physical courtroom? Is Mr. Nerat in the physical courtroom? Mr. Sasong, it would appear this was scheduled for 8:30. It is now 9:18. And I don't see Ms. Fox or Mr. Nerat in the courtroom. I do have proof of service. I do have proof of service to Kimberly Fox. How did you want to proceed, Mr. Sasong?
Your Honor, counsel had filed an answer in affirmative defenses by pleading is dated May 30th. Proof of service of the same indicates that was served on our office. The address as set forth by counsel, defendant's counsel in the pleadings is 700 West Barnes Avenue, Lansing, Michigan, 48910. I note as well for the record that the court issued a notice to appear on May 31st, 2023. That's when it was issued, the notice to appear. It does appear that the notice to appear does contain counsel's correct address, and it appears that notice to appear was served by the court as well on counsel for the defendant. Given our office hasn't been contacted by counsel in advance, given all those facts, Your Honor, plaintiff would accordingly move for the entry of a default judgment against the defendant for the relief requested in the complaint in addition to taxable court costs and a statutory attorney fee.
All right. What I'm going to do, since we both don't have the client or the attorney here, is that I'll take your motion under advisement. And I'm going to reset this pre-trial since it appears that an answer, an affirmative answer, were sent. So I don't know. I'm at a loss too as to why the attorney and the plaintiff and the defendant are both not here in the civil matter, but we'll reset the pretrial. And I'm going to indicate for the record that the defense and attorney were not present. And at the adjourned pretrial date, we'll ask for some confirmation as to why they did not appear today. There must be a reason, I would think, since they got notice and everything. I know Mr. Narot, I know that, that he 9 times out of 10 he shows up. So I'm a little concerned about him not showing up. And I don't know the reason, but we'll adjourn the date to July 26th at 9 a.m.
Very good, Your Honor.
And we'll, at that time, we'll confirm any reason for the absence today. All right, Mr. Sassong?
Understood, Your Honor.
All
Thank
right.
you very much and have a nice holiday.
You too. Thank you. That's all for the record, 2301102. Now, Ms. McCray, how would you like to proceed?
Thank you, Your Honor. Okay, I think that Mr. Ackley, who I believe is on Zoom, right, Jared?
He was on there earlier. I don't see him now.
You might have removed him.
Oh, he's still, looks like he's still there.
All right. Is that
Dayton?
Dayton Ackley?
Dayton Ackley? All right.
Yeah, I'm still here.
All right. Stand by, Mr. Ackley. I think we're going to call your case next.
Okay.
Is that right?
Yes,
Ms. McCray?
yes.
Then we're that's
On Ackley.
all right. So we're on the record in docket 2301963. That's people in the state of Michigan versus Dayton Ackley. Will the parties please introduce themselves for the record?
Andrea McCray appearing on behalf of the people.
And good morning, Your Honor. Jared Austin appearing on behalf of Mr. Ackley, who appears with us today remotely via Zoom.
And sir, you are Dayton Ackley?
Yes, sir.
Okay, and you can hear me all right, Mr. Ackley?
Yeah.
All right, just the time set for a probable cause conference. Ms. McCray, how are we proceeding?
Thank you, Your Honor. After speaking with brother counsel, I believe this matter is going to be left on for preliminary examination next week.
And that's your understanding, Mr. Austin?
It is, Your Honor, and that's what I would request as well.
All right. So this will be left on for preliminary examination on July 7th at 9 a.m. So, Mr. Ackley, we're leaving your prelim on for July 7th, next Friday at 9 a.m. All right, sir?
No. Yeah, excuse me, sir.
Your Honor.
Yes? I wouldn't talk about.
If I may, I don't mean to.
I wouldn't talk about the case at all. So what is your question? But go ahead.
You want to wait? Can I waive the 21 days?
Mr. Ackley, hold on a second, Your Honor. Hold on a second, Your Honor. Mr. Ackley, Your Honor, may I interject? I apologize. Not to interject on the record, but wanted to bring some things to the court's attention in regards to this matter. Although we have not appeared and filed an appearance on this matter, did have contact with Mr. Ackley last night. Although I'm here for another matter, he did contact our office last night in preparation to potentially retain our office in regards to this matter. We have advised Mr. Ackley to waive the 21 days, which he is in agreement with. I just wanted to make the court aware of
Mr.
those
Austin.
things.
All right, but
That to be when I spoke with him.
yeah, well, Mr. Austin's here. He is the attorney of record. I think let's leave it on and if council wants to file an appearance and then waive the 21-day rule, I think we'll accept that, but by next week. That's not an issue. So once to make sure that you're retained and you file an appearance. Okay, Mr. Neal?
Yeah, Your Honor, I was just bringing it to the court's attention, given the holiday schedule, we were going to try to attempt to meet with Mr. Ackley, but we'll abide by the court's ruling.
All right, and I think you can always contact the APA in order to waive the 21-day rule. But I just don't have any appearance right now from other than the people in front of me. But I thank you for that. That catches us up on that he may be applying for a new counsel, which I think was news to Mr. Austin at this time.
Yeah, I spoke with Mr. Ackley, Your Honor, yesterday. I was unaware of that. That wasn't brought to my attention at that point. It may have subsequently developed, but.
Right. Okay, so Mr. Ackley, you're still on schedule for July 7th, 2023. If you plan to retain counsel, make sure that Mr. Austin and your counsel of record knows that, and then we'll go from there. All right, sir?
Okay, Your Honor.
All right, thank you. That's all for the record. 23-01963. We'll see everybody. If nothing happens, we'll see everybody here on July 7th at 9 a.m. Thank you for your appearance today.
Thank you, Judge. Mr. Austin also has Sharita Walters, which I'm seeing on your docket is set for forensic review.
Correct.
Okay.
Do you want to call that one?
Yes. I'm not really sure what's going on there.
I'm not
I would love
either.
to call it. Sure.
Hold on.
There you go. Hey, babe, bring me that cord. My phone is about to die. Oh, excuse me. I blow my nose so bad. Blow my nose so bad. Oh God. God, this just break it up so bad. Bro, with the color. I need some tissue. I was about to run on my damn face. It's all crazy. Oh. Oh. They keep muting itself.
All right, so we're on the record in docket 23-01800. That's People of the State of Michigan versus Carl Knox. Will the parties please introduce themselves for the record?
Andrea McCray appearing on behalf of the people.
Good morning, Your Honor. John Abbott with the Public Defender's Office. Representing Mr. Knox, he's on video today.
And sir, you are Carl Knox? Okay, and you can hear me all right, Mr. Knox?
I hear you.
All right, this is the time set for a probable cause conference. Ms. McCray, how are you proceeding?
Thank you, Your Honor. Upon speaking with Brother Counsel, we are going to leave the matter on for preliminary examination next week. Brother Counsel did inform me he has not received the police report. As soon as I can get my computer working, we'll get that resolved today.
All right. And that's your understanding, Mr. Abbott, and you've made a record that you're awaiting a police report on this. We're leaving the prelim on for July 7th, 2023.
Yes, thank you, Your Honor.
All right. So Mr. Knox, we've had the probable cause conference, and my understanding is we're leaving this on for next week, July 7th, next Friday at 9 a.m. If you have any questions, please keep in contact with your attorney, Mr. Abbott. Okay, sir?
Mr. Knox, I'll get the police report and come see you.
All right. That's all for the record, docket 2301-800. Thank you, Mr. Abbott.
Mr. Etheridge, do you want to do your?
Other guy. And you're all set, Mr. Knox. Thank you.
I mean, I've had.
All right, so we're on the record in docket 23-01884. That's people of the state of Michigan versus Emilio Betancourt. Will the parties please introduce themselves for the record?
Andrea McCray appearing on behalf of the people.
Morning, Your Honor. Attorney Derek Custis, Office of Public Defender, on behalf of Mr. Betancourt. I'm here in the courtroom. Mr. Betancourt is appearing by Zoom.
And sir, you are Amelia Betancourt?
Yes, Your Honor.
Okay, and you can hear me all right, Mr. Betancourt?
Yes, sir.
All right, this is the time set for a probable cause conference. Ms. McCray, how are you proceeding?
Thank you, Your Honor. So my understanding, and understand that I'm standing in today, but from speaking with brother counsel, is we're trying to get this transferred over to Judge Ward's DV court. So at this time, I think we want to leave the exam on for next week.
Yes, Your Honor. We're asking the court to leave the matter on. We're looking into transferring this to Judge Ward for domestic violence court. There's a preliminary plea offer to plead to DV second. We've asked for an agreement of no upfront jail. Mr. Broderick and Mr. Stevens are asking Judge Ward about that, and will let us know between now and next week.
All right, so this time, with the anticipation that there's a plan, we're leaving it on for prelim on July 7th at 8:30. And the plan is to see if Judge Ward is accepting of the case to DV court. Is that correct?
Yes, Your Honor.
All right. All right, Mr. Betancourt, you understand that we're leaving this on for prelim for July 7th at 8:30. However, keep in contact with your attorney, Mr. Etheridge, as there's a plan here concerning another judge's court. All right, sir?
Okay, Your Honor.
All right. Anything else for the record in docket 23-01884, Ms. McCray?
No, thank you, Your Honor.
Mr. Etheridge?
No, Your Honor. Thank you.
All right, thank you. Mr. Betancourt, you're all set. Thank you for your appearance today.
Thank you, sir. I appreciate you. Have a good day.
You too.
Judge, I believe we're ready on Corey Navarro.
Yep. Okay, we're on the record in docket 23-01939. That's people of the state of Michigan versus Corey Navarro. Will the parties please introduce themselves for the record?
Andrea McCray appearing on behalf of the people.
Attorney Derek Custis, Office of Public Defender, on behalf of Mr. Navarro, I'm here in the courtroom. Mr. Navarro is appearing by Zoom.
And Mr. Navarro, you are Corey Navarro, sir?
Yes, Your Honor.
Okay, and you can hear me all right, Mr. Navarro?
Yes, Your Honor.
All right, this is the time set for a probable cause conference. Ms. McCray, how are we proceeding?
Thank you, Your Honor. After speaking with brother counsel, I do anticipate that we are going to leave this set for preliminary examination next week. I just will make a note for the record that the victim does appear in court.
All right.
Your Honor, that is correct. I talked to Mr. Broderick, and he's offered a specialty court, but he's trying to decide whether mental health court or sobriety court is more appropriate. So I foresee next week the parties waiving the 21 days for that assessment to be completed.
All right. May I inquire of your client his preliminary examination for next week, Mr. Etheridge?
Yes, Your Honor.
Mr. Navarro, you understand that we've now completed the probable cause conference, and it has been left on for preliminary examination on July 7th, 2023 at 8:30. There's been some contact between your counsel and the prosecutor's office concerning a specialty court, but at this time, you're still on for July 7th of 2023.
Yes,
Do you
sir.
understand that, sir? All right. Please keep in contact with your attorney, Mr. Etheridge. Anything else for the record in docket 2301-939, Ms. McCray?
No, thank you, Your Honor.
Mr. Etheridge?
No, Your Honor.
All right, thank you.
You wanted to call Davis? Is he here? Okay.
You're not Mr. Davis, right?
Aaron Davis?
But I told him.
Okay, so how does that work? Does he work on or does he need to appear?
And Mr. Navarro, you're free to leave the Zoom courtroom. Thank you for your appearance today.
Thank you, Your Honor.
Oh, so you've already. So
Mr. Neal, did you need to speak to anybody about your probable cause conference on Kelso?
Your Honor, I believe I've had an opportunity to discuss this matter with my client who is present via the video system. We were just recently retained yesterday in this particular matter. We, as such, we don't have the discovery or anything. As such, my client understands he has a right to have the exam within the 21-day time frame, which he is willing to waive. We'd ask the matter be reset for a second PEC. I believe we may be able to have decisions made by then.
I don't see Mr. Kelso on here.
He's listed under Mr. Wesley, under Miss Wesley.
Okay, that's Mr. Kelso.
Yes.
All right. So that is Edris Kelso.
You want the case number, Judge?
No, I've got it. Okay. All right, so let's call that one. So.
Okay.
So we're on the record in docket 2301-881. That is people of the state of Michigan versus Eldris Eljohn Kelso. Will the parties please introduce themselves for the record?
Andrea McCray appearing on behalf of the people, P number 83698.
All right.
Good
And
morning,
I
Your
do
Honor.
not have counsel.
O'Neill.
I do not have counsel because the court appointed was denied, but now Attorney Rico Neal is present, and your appearance for the record, sir.
Rico Neal, appearing on behalf of Mr. Kelso, Your Honor, who is present via the video system.
All right. And sir, you are Idris Kelso?
Yes, sir.
All right. This is the time set for a probable cause conference. My understanding, Mr. Neal, is you've been recently retained, and so I'll let you make the record on this.
That's correct, Your Honor. I was just recently retained yesterday. We, as such, my client understands he has a right to have the exam within the 21-day time frame. At this time, he is willing to waive that right and have this matter rescheduled for, I would request a second PEC. If there are any offers that are going to be made, I would ask that they be placed on the record so that I can have an opportunity to discuss those with my client as well.
All right. Are there any offers at this time from the people?
There's no offer.
So no offer from the people at this time, Mr. Neal.
Thank you, Your Honor.
All right. So may I inquire of your client of the waiver of the 21-day rule?
Yes, you may.
All right, Mr. Kelso, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. You understand that, sir?
Yes, Your Honor.
And a preliminary examination is a probable cause conference, a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. Do you understand that, sir?
Yes, Your Honor.
You would be represented, or you will be represented by Attorney Rico Neal, who will be present to cross-examine any witnesses and test any charges brought against you in that proceeding. Do you understand that, sir?
Yes, Your Honor.
It's my understanding you wish to waive your right to a preliminary examination within that 21-day period. You wouldn't be waiving your right to a prelim in general, only within that 21-day period, so that Mr. O'Neill can receive the information he needs to zealously advocate for your defense. Is that my understanding, sir?
Yes, Your Honor.
Do you wish to waive your right to a prelim within 21 days, Mr. Kelso?
Yes, Your Honor.
Yeah, I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will reset this date, and then Mr. Neal, you can check your schedule because I know you've got a schedule, so we'll run it. We'll run the date. July 20th at 8:30. Does that work?
July 20th. Let me look, Your Honor. Your Honor, do we have is there a second date, Your Honor, we could use? 25. Well, is it going to be in the morning or if we could do the afternoon, that's fine.
Yeah, we could do an afternoon.
Afternoon would be fine, Your Honor. July 20th in the afternoon.
All right, so we'll set it for July 20th at 1:30.
Via Zoom, Your Honor.
So in the the prelim will be live. That one will be live.
Okay, that's for exam. Okay, thank you.
All right. All right. So, Mr. Kelso, please keep in contact with your attorney, Mr. Neal. Your prelim is set for July 20th at 1:30. Okay, sir?
Okay, thank you.
All right. Anything else for the record?
Thank you, Your Honor.
2301-881, Ms. McCray.
My understanding from speaking with Mr. Etheridge, that there is a co-defendant on this case. That would be Aaron Davis, who's also scheduled today for PCC. I just asked that we join them so that we can hold the exam at the same time.
All right. But so
We can go on record maybe for Davis after this case.
yeah, let's go on record for Davis after this case to see, because we'll need a waiver on that one.
We intend to waive next week, Your Honor.
Okay. All right. All right. So that's all for the record in docket 2301-881. Mr. Neal and Mr. Kelso, thank you for your appearance today.
Thank you, Your Honor.
Thank you.
All right. And then we're on the record in docket 2301-880. I'm sorry. That's the one we just did, right? Well, that's Mr. Kelso. Now we're Mr. Davis. 2301-880. That's People of the State of Michigan versus Aaron Davis. Well, is Mr. Davis here?
No, Your Honor, I have had conversations with him and interviewed him around June 28th, and I've had conversations with the prosecutor this morning. And our intent was to waive the 21 days next week.
Okay.
For investigative purposes, and now also because of the code.
All right. So we're just leaving it on for today, and he'll waive next week.
Yes, Your
All
Honor.
right. All right. So as indicated before, we're on the record 2301-880, counsel's appearance for the record.
Andrea McCray appearing on behalf of the people, P number 83698.
Morning, Your Honor. Attorney Derek Hector, Office of Public Defender, on behalf of Mr. Davis. Mr. Davis is not in the courtroom at this time. I have had conversations with him and had a discussion with Mr. Brodowitz regarding the case.
All right. So it's my understanding, Ms. McCray, how are we proceeding today?
Thank you, Your Honor. Well, first and foremost, I would move to join Mr. Davis with Idris Kelso's case, because my understanding is they are co-defendants. I'd like to hold that preliminary examination at the same time. The date that was previously given for Kelso was July 20th, 2023 at 1:30. However, being that Mr. Davis is not present today, my understanding is we're going to leave it on for next week, and that brother counsel and his client will enter the 21-day waiver at that time.
And is that an accurate statement, Mr. Etheridge?
Yes, Your Honor. I have had conversations with Mr. Davis and advised him that be my desire to wait the 21 days because I need to have my investigator go to the police agency to look at the physical evidence that was collected.
All right. So it's my understanding we're leaving this on for July 7th, 2023 at 8:30. There is a plan. I will grant the motion for joinder to join this case with the co-defendant, Mr. Kelso. That prelim has been set for July 20th, 2023 at 1:30, but we will await next week's waiver of the 21-day rule to place this with the co-defendant. Is that my understanding, Ms. McCray?
Yes, perfect.
Mr. Etheridge?
Yes, Your Honor. And he is a listed co-defendant on the complaint.
Yes, he is.
On my complaint.
All right. So anything else for the record in docket 2301-880, Ms. McCray?
No, thank you.
Mr. Etheridge?
No, Your Honor. Thank
All
you.
right. You should be all set. Thank you for your appearance today.
Judge, I think we are ready on the Omar Thompson PCC. My understanding from Mr. Berry is he is on Zoom.
All right. Is Mr. Berry on Zoom?
Mr. Berry. He's right here.
Right there he is. Mr. Thompson's there.
Yeah.
So let me grab that file. Omar Thompson. All right. So we're on the record in docket 2301-964. That's People of the State of Michigan versus Omar Thompson. Will the parties please introduce themselves for the record?
Andrea McCray appearing on behalf of the people.
Good morning, Your Honor. Ronald Berry appearing on behalf of Omar Thompson, who is joining us via Zoom.
And sir, you are Omar Thompson?
Good morning, Your Honor. Yes.
And you can hear me all right, Mr. Thompson?
Yes, sir, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Ms. McCray, how are we proceeding?
Thank you, Your Honor. After speaking with brother counsel, my understanding is he seeks to adjourn the preliminary examination that was scheduled for next week. Is that correct?
That's correct, Your Honor. Due to the timing, I was asked to accept this case from the Public Defender's Office as a conflict counsel on Wednesday afternoon. Thursday morning yesterday, I filed my appearance and demands, and I don't have anything yet from the prosecutor's office. Given the fact that we're going into the holiday weekend, I'm not certain as to when I'm necessarily going to get that, and if I'm going to have the opportunity to receive everything and review it before. So rather, than having the likelihood of having to appear again to request adjournment and having called witnesses, I would just ask to waive the 21 day right now. Mr. Thompson's prepared to do that and have this rescheduled to a new date.
All right. And there's no objection to that from the people?
No, of course not.
All right. So may I inquire of your client of his waiver of his 21-day rule?
Certainly, Your Honor.
Mr. Thompson, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment. You understand that, sir?
Yes, sir, Your Honor.
A preliminary examination is a probable cause hearing in which the people would have to prove by witnesses and evidence that there's probable cause to believe that the crime was committed in this file and the identity of the person who committed the crime in this file. You, of course, would be represented by Mr. Berry, who would be present to cross-examine any witnesses that contest any charges brought against you. Do you understand that, Mr. Thompson?
Yes, sir, Your Honor.
Now, Mr. Berry today has requested that we adjourn the matter outside of the 21-day period so that he can zealously represent you and get all the information needed in order to pose a zealous representation. Do you understand that, sir?
Yes, sir.
All right. It's my understanding your wish today is to waive your right to a prelim within that 21-day period. You wouldn't be waiving your right to a prelim in general, only to waive it within that 21-day period. Is that correct, sir?
Yes, sir, Your Honor.
All right. So it's your intent today to waive your right to a prelim within 21 days. Is that correct?
Yes, sir, Your Honor.
All right. Thank you. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will get a new date. And Mr. Berry, I know you're in court, so we'll get a new date and then we'll try to run it by your schedule.
July 20th.
July 20th at 8:30. Does that work?
It does work.
All right. So we will set this for July 20th at 8:30. Anything else for the record? Docket 23-01964, Ms. McCray.
No, thank you, Your Honor.
Mr. Berry.
No, Your Honor. Thank you.
All right, thank you. Mr. Thompson, you're all set. Please keep in contact with your attorney, Mr. Berry. Your examination is set for July 20th at 8:30. All right, sir?
All right, thank you. And
All right, you're free to leave the Zoom courtroom. Thank you for your appearance today.
We'll be in touch soon.
Okay, thank you.
Guys, with that, I do believe your PCCs have been completed for this morning. Mr. Carter's laughing at me. So I think that I was hoping that I could turn it over to Jeff to start some fun prelims. All right. Does Your Honor have probably the 8:30 one, I'm assuming, right?
Well, whichever's ready to go. Yeah.
All right, let me go get him.
All right.
I have at least 5 minutes, so don't I?
Yes, you do. Because Eskin and Gaskin are both co-defendant. We've got have to go this morning.
At least get something moving.